Hi, my name is Jed McKeehan, and I'm an attorney at the Hurley Law Firm. And today we're going to talk about the trial in a case. We've talked about all the things that lead up to the trial. Now we're going to talk about the part you see on TV and all those shows that you watch, the actual trial of a case. And now a trial can be tried in front of two different people who will decide the outcome of the case. The first is just a judge, and the second is obviously a jury, and that's the 12 people who are picked from the community who will decide the outcome of the case. A judge will sit as the decider of a case in a divorce case. There's no juries in divorce cases, and a typical case where a jury is present is a car accident or some sort of criminal case. There's almost always a jury present. Now there are generally basically four different parts of a trial, and I'm going to go through those and tell you what those are. The first is the opening statements. That is when the attorneys will stand up and either speak to the judge or the jury about the merits of the case and why their side should win, and persuade with arguments and stories and things of this nature. Now the plaintiff's attorney, that's the party who is sued, will always go first, or the prosecution, the person prosecuting the crime. They will always go first, and then the defendant will follow after them. After the opening statements have been made, the plaintiff or the DA will put on their proof. And what the proof means is testimony of witnesses. So they will call witnesses to the stand to testify in furtherance and to back their case with what they've seen, what they've experienced, and things of that nature. And they will ask them questions, and that's called direct examination. After the plaintiff has asked questions, then the defendant attorney will be able to cross-examine those same witnesses. And that's the part on the TV shows where you see Matlock or Tom Cruise asking all these sneaky, tough questions and getting someone to confess to a murder or something of that nature. So after the cross-examination has taken place and the plaintiff has called all their witnesses, then the reverse happens. The defendant calls any witnesses on their behalf, and then the plaintiff can cross-examine those witnesses. And then after all the proof has been put on, then the attorneys make closing arguments. And this is where they will sum up what has been said in testimony. They will make their last persuasive arguments to the judge or the jury. And then at that point, the judge and the jury will decide who has won the case and what they have won, either monetarily or property, or what the sentence will be, things of that nature. So you've got the opening statements, the proof of the plaintiff, the proof of the defendant with direct examination and cross-examination of both, and then closing arguments. So after you've gone through this whole process and you've had the trial of the case and you've won, you've actually won your case, then you think you're all done. Well, that's not necessarily the case. In our next video, we'll talk about what happens after the trial of a case.